Rebuttal.
Thank you, Your Honor. I'd like to make. There's been some questioning of the court of my colleagues on the other side of this podium as to whether the evidence was false, and he suggested that the evidence wasn't false, and therefore it was okay. Well, that of course isn't the test. It's whether the prosecutor not only knew it was false, but should have known it was false. And the prosecutor in this case certainly should have known that his theory in the Sakarias case was false. After all, only months earlier he had told a jury of 12 people the exact opposite. Should he have known? Certainly. 4 months earlier, when he argued the new trial motion in the Waidla case, he told the judge the exact opposite theory. And then, of course, only a few months after that, when he submitted a memo to his superiors, and that memo is part of the lower court file from the evidentiary hearing, he submitted a memo to his superiors asking for life for Sakarias precisely because he believed in the Waidla theory. So, whether he knew it or not, I can't get into the prosecutor's case head. But should he have known it was false? Absolutely.
I understand you're arguing for your client, who's Mr. Sakarias, but do you see a difference between the two cases insofar as this court finding a violation of due process and or prejudice?
Well, Your Honor puts me in a difficult position. With respect to my client, I can argue as to prejudice, and I'll do that now. Of course, as to the Eighth Amendment, the state's current concession that it doesn't know if either of the theories were correct, I think, is an important concession the court should consider in terms of the Eighth Amendment argument. In terms of the due process argument, there's been some suggestion that it made no difference to my client. The jury in the case, my client's penalty phase, given the arguments that it was presented with and the evidence it was presented with, deliberated 12 hours and expressed the opinion that it was deadlocked. It couldn't decide if Mr. Sakarias should live or die. Could this argument have made a difference? Chief Justice asked a number of questions as to why the prosecutor would do this, if he didn't think it was important. And of course, I mentioned this earlier and I'll echo it here. One of the problems with inconsistent arguments is that it forces the state to do inconsistent arguments once again. I mean, the prosecutor stood up there and he told the jury this was critical. That's the prosecutor's word. This was the death blow. We're now told that that was hyperbole. Well, the jury didn't know it was hyperbole, and the jury didn't know it was false, and the prosecutor knew it was false.
Mr. Gardner, do you rely heavily on the finding by the referee that the weight or the great weight of whatever evidence was available to the referee indicated that the victim was dead or near death when she was dragged into the bedroom, and thus that it was defendant Waidla rather than your client Sakarias who administered the antemortem hemorrhagic hatchet blow. Here we're dealing with the penalty phase. Presumably, your argument is that in falsely attributing the fatal blow that was administered to the victim to your client, Sakarias, it deprived your client of a fair penalty trial, and therefore relief should be granted. Is that, in a nutshell, your argument?
In a nutshell, Judge Wilhite's, it is exactly it. Judge Wilhite's finding satisfies Judge Tashima's view of prejudice. I've already commented the fact that I was precluded from presenting forensic evidence, and now the state is suggesting that it's harmless because I didn't present the forensic evidence. But Judge Wilhite's finding does compel a finding under Judge Tashima's view. Another point I'd like to make is that there was some discussion, I think Justice Werdegar, you and my colleague Mr. Keller had this exchange about whether this was just an omission or whether it was actually presentation of false evidence. And I am troubled by the state's notion that by not presenting these truthful things, they didn't really present false evidence. And I am reminded as I sat here and listened to Mr. Keller's argument of something my grandmother said, and it sounded much better in her language, and I won't trouble the court with my rendition of her language, so I'll translate it. And it's a half-truth, it's a whole lie. And that's what we have here.
But there was no Brady violation. There was no withholding of the additional evidence.
That's absolutely right. There was no withholding. Could the adversary system have dealt with this? Maybe. But in the Brady context, we don't rely on the adversary system to resolve this. I'm sorry, the Nepew context, presentation of false evidence. If a prosecutor has given a witness a deal and calls that witness to testify and discloses that deal to defense counsel and says, Mr. Witness, did I give you a deal for this testimony? And the witness says, nope. And the prosecutor knows that witness is lying, we don't say, you know what, the adversary system is good enough. defense counsel missed it, but he had the information, and that's good enough. No, we hold the prosecutor to a higher standard, and that's what I think we should. I'm hoping the court's opinion will reflect that. It's certainly in Seaton, it reflected the idea that if a prosecutor has serious doubts about the theory or evidence he or she is presenting, that prosecutor is held to a different standard than other lawyers.
That is conclusive evidence. In other words, if a deal has in fact been made and it's denied, I mean, that's conclusive evidence. There's no way to get around it. And again, we're dealing here with inconclusive evidence.
Well,
You may answer, but your time is otherwise up, Mr. Gardner.
Judge Wilhite certainly didn't think it was inconclusive, Your Honor. What he felt was that the great weight of the evidence supported one view. And I think the correct answer is that if a prosecutor makes an argument against the great weight of the evidence that he himself knows to be true because he relied on that great weight of the evidence in convicting a first defendant, then that's a problem.
Thank you, Mr. Gardner.
Thank you, Your Honor.
Mr. Kennedy, we'll hear from you by way of rebuttal.